the March 12th, 2025 Centerville City Planning Commission. Looks like everybody is here, and we also have a new member, Gary Woodward, right? Which we're super excited about. Gary, would you be willing to introduce yourself just briefly?
Sure, I'm Gary Woodward. We live in North Centerville, 1750 North. We've been there for 31 years, I think, something like that anyway. We love it here. We've loved living in Centerville. My background is I graduated from Utah State in landscape architecture and environmental planning. I said the emphasis was not on the environmental planning part of it. So I know more about landscape architecture than I do about planning, but happy to be here, happy to help. I have recently been on the Centerville City Tree Board. So this is a change from that to this, and that's been interesting. We were, the tree board was formed about 7 years ago, and I was one of the original members of the tree board. So as I leave, the rest of them are all come since then. So that was a fun board to be on. So I'm looking forward to the Planning Commission and see what happens here. Thank you.
That's awesome. I hope to retire to the tree board. That sounds nice. That sounds really nice. All right. We are going to start with a legislative prayer thought. And I just am going to do it today. Given the shift, I know I sent out an email with the breakdown, and I had forgotten, Gary, that you had joined us, and so I need to redo the whole thing.
Oh, okay.
So we go on a rotating basis. Once every meeting, someone else does a legislative thought and or a prayer. So today I took it. So there's an old story about a man who sat under the shade of a tree that he didn't plant. This is very apropos. As he rested, he watched a farmer nearby who was digging a hole prepared to plant a sapling. The man asked, "Why are you planting that tree? You'll never sit under its shade." The farmer wiped his brow and replied, "Maybe not, but someone will." And in Centerville, many of us have lived under the shade of trees planted long before our time, both literally and figuratively. Our streets, neighborhoods, and community traditions were shaped by those who came before us, people who made decisions with an eye towards the future. But every generation reaches a moment where it must decide how to care for what has been built and how to prepare for what is to come. And today, in Utah especially, we find ourselves at such a crossroads. Growth is just not an abstract idea. It's here, and it's knocking down our doors. And more people want to call Centerville home than ever before. And that reality brings a lot of questions and concerns and a lot of emotions. And it's natural to feel very protective of what we love. We don't want to lose the character of our town and our familiar streets or the feeling of community that makes us special. But the question in front of us isn't whether or not we can affect it. The question is not simply whether change will happen, it's whether or not we can shape it. Change is going to happen, it always has. So will we plan thoughtfully, ensuring that Centerville remains not just the place we love today, but the place that future generations can love as well. Our responsibility as planners, as community members, isn't to erase the past, and it isn't to fear the future, but to build a bridge between them, to guide change in a way that protects what we cherish while making room for those who one day will sit under the shade of the decisions we make today. So as we deliberate, let us listen not just to our own voices to each other. Let us debate not for the sake of argument, but for understanding. And let us decide not just for today, but for the future of Centerville, the people who will call it home now, and the people who will call it home long after we are gone. I'll say a quick prayer. Father in heaven, we're very grateful to come together and to do the public's work here in the public forum. We ask for thy blessing that we can make wise decisions. And we thank thee for thy blessings and say this in the name of Jesus Christ. Amen.
Amen.
If you'll stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, so we have a number of business items on the agenda. There are 4 total. We'll proceed as posted. There are 2 administrative decisions and 2 legislative decisions. We'll start with the administrative decision, public hearing for the commercial subdivision concept of Legacy Commons.
would you like me to do? an
Yes,
introduction
Mr. Agate,
here?
if you'll take the show from there.
Okay. So, as noted in your packet, and Sydney, if you'll scroll just a little bit to the inset photo, that's the location of the site. That's on the corner of Parish Lane and 1250 West. It's the northwest corner. It's 8.55 acres. It comprises 2 parcels, which are identified as 06-006-0118 and 06-006-0082. The zoning is currently zoned commercial very high. There are some future anticipated uses for the property. Subdivision at a later date would involve a conditional permitted use request for the site, were there to be a subdivision approved for proposed lot 2 of the subdivision submittal. The applicant is very motivated to move forward through the subdivision process, and they do have a partner site plan submittal request that has been provided to the city that will come forward at a later date for lot 2. So just a heads up there. There is a public hearing requirement for the subdivision request per city municipal code 15.01.130. To that point, public hearing notice was provided and the sign was placed on the property in compliance with that code. During the time of the report, we did not provide commentary. However, we have since received earlier today commentary from the neighboring property, the North Centerville Flex Project LLC, through their legal representation, that property ownership has provided a prescriptive easement claim for a portion of property on the north end of lot 1 in the corner. There's an area of parking that they've been utilizing for, they claim in their letter, over 20 years. So I want to make sure that's on record. If at some point members of the planning commission would like to see that, I can clearly email that to you, but that is the letter that they want. I want to make sure it's clear on the record for that claim. So, and I have that provided to our city attorney as well, so she is aware of that from our earlier email today. With that point, moving in, and we did not receive any other commentary other than that inquiry. So moving into the commentary, as we're required and guided by CMC 15.02.050, there's 3 key components, and I've broken those down in review, but the bottom line is the first one is scheduling the public hearing, holding the public hearing, and then making sure that there's compliance to what's expected in meeting general plans, zoning code, subdivision ordinance, and other applicable ordinances and regulations, and I'll get to that in a minute. The second one is making sure that the planning commission understands that you can always request more data and information if there's a need to even table this matter for further deliberation or discussion. And then the third point is just to make it clear that approval of subdivision concept does not obviously constitute any approval or disapproval of the subdivision. In that stage, it's just advancing to the next page or the next phase of the project subdivision. There will be 2 more steps following conceptual subdivision in theory, which would be a preliminary subdivision application review process, which would go to the planning commission. And then the third step, or to get to that point, would be a final subdivision application review process, which would go to the city council. So just so you can understand where we sit with the progression on this. So that being said, in looking at all of the number 1 points, checking the general plan, the zoning code, the subdivision ordinance, applicable ordinances and relations or regulations at the time of submittal, this proposal has gone through a full design review committee review with city staff, which is composed of the city engineer, the city's public works department, and department leadership as far as like the roads representation, the water representation, the storm drain representation. They're all been part of those discussions with the applicant group, as well as city attorney, city planner, and myself. So it's a pretty robust group where we review everything. And I think I said the city engineer. If I didn't, he's in there as well. So anyway, it's gone through full review. It has met the requirement for a complete application submittal, and you'll see the evidence of that letter in your packet following the initial report, as well as from staff's review. You'll see in the checklist document there is compliance with what is required for a conceptual subdivision submittal. So from staff's perspective, the application has met completeness and compliance review requirement. That being said, there have been additional comments that were noted during the DRC review that are preliminary, I guess you'd say preliminary guidance or recommendation things, that if this were to advance to preliminary subdivision application and review process would be looked for. So those comments are provided at the end of the checklist as guidance to the applicant, but also just so you can kind of see the nature of where we're already progressing in our design review committee review of the site. So to that point, the planning commission, you are the administrative processing decision maker for the conceptual plan and plat. at this time. That's what's being represented to you. You do have in the packet the sample motions and the findings for said motions, reflecting hopefully what I just talked about with you in those motions, and then the findings that do show compliance with City Municipal Code 15.02.020 and 15.02.050. As a quick survey of the documents that have been provided in your packet, like I said, there's the letter of completeness, the compliance checklist, there's from the applicant on that, there's an application information page that they're required to do with a short narrative about legal description and what they have noted about the site. There's the plat itself, there's an ALTA survey requirement that they've met what's required for the conceptual application there. A vicinity plan map has been provided. They also provided an initial title report that they're required to. I just didn't include in the packet because it's involved, but our city attorney has received that title report. And then you'll see the public hearing notice requirements at the bottom of that, the evidence of those being provided. So with that, I guess that's long and short of the introductive narrative on it. And I defer back to you, Chair Kerr, how you'd like to proceed with this.
Mm-hmm. So I had a couple of questions on the preliminary of the PDF. There's like a circular cutout that's going to be a roadway dedication. Are they putting, is that for planning ahead for a roundabout?
That is per our city engineer, and that the answer is yes, that's correct. It's to create the dedicated right-of-way for a future allocation of that roundabout.
Fair enough.
Yeah.
And then page 19 of the PDF has an aerial. I'm just trying to understand what you were talking about, the possibility of a prescriptive easement. Would you mind going to PDF page 19? Well, it's not going to be the same as yours. It's the aerial of the site.
So is it
Where you-
under ALTA survey maybe?
Previous to the
Yeah,
site.
yeah. Maybe go down
I think it was,
to, or is it the vicinity plan?
it's higher.
Yeah, maybe, but, yeah.
Yeah, that one right there.
Okay, yeah, see on the upper northwestern edge, you can see a bunch of dirt and vehicles. That is the prescriptive easement area.
Okay.
That's being noted.
There's another picture in the packet with without the overlay.
I think that was
If
this
you,
one?
no, go up, sorry, go down, one more, and then scroll down a little bit.
Oh, there you
There.
go.
And then
On their
zoom in.
floodplain map, yeah, you can see that.
Is-
So you,
Is that what you
yes.
were talking
so-
about?
Oh,
Yes,
that's
so the property line typically would end at the edge of those buildings.
Oh,
But you can see as it
yeah.
continues westward in somewhat straight line, that area of parking and dirt, that's.
Has been
occupied
used for
land
20
space.
years?
Well, at least you're saying that someone has filed a notice.
There's been a
that
file,
they-
and it's been recorded with the county as a notice of claim.
all right.
Does that change
They
anything?
provide us evidence of that.
Does that change anything?
From a conceptual application and requirement perspective, there are no easements required for the conceptual application review. So no easements would have been identified or required to be provided on the plat submittal. However, the preliminary review process, all easements will need to be identified and embedded by the staff.
All right, so thank you, Mr. Eggett, I appreciate that. Who is here to speak for the applicant? Sir, would you, if you mind coming to the mic, state your name and just anything that you'd like to present to us?
You bet, yeah, Spencer Wright, Wright Development Group, 1178. Do you need an address still?
Sure.
Okay. 1178 West Legacy Crossing Boulevard, Suite 100 in Centerville. Thank you for your time this evening. Yeah, from our standpoint, it's a pretty simple two-lot subdivision. We understand that the city needs to verify that we comply with the ordinances of the city code as we do that. But I think Mike's done a great job of explaining what we're up to tonight. And I also bring you the greetings of Logan Johnson. I believe he knows some of you as well, so he said to say hi to you. Make sure I do that, but happy to answer any questions that you have.
I'll open up the floor for questions. So I had questions, just because I'm trying to understand this. What are you going to do about the prescriptive easement?
Well, yeah, that's a good question. I think it's amazing to me that someone believes that they should be able to take something from someone else You know, we bought the land about 5 years ago, and apparently their argument is, well, we know you paid for the land, but we think you should just give some of it to us.
Can I pause? My question was poorly articulated. More along the lines of, what are we as a city supposed to do if that isn't resolved down the road?
I don't think it's an issue for the city at all. This subdivision does not affect that issue. It's a separate issue. We're simply taking one parcel and separate it into two. And that we don't believe there is an easement there, and we think that the legal process will bear that out. But from our perspective, it does not impact our ability to subdivide this property.
Okay, I understand. And then, why are you subdividing it in this shape?
We're subdividing it in that shape because the proposed site plan that would go on Lot 2, that's the site constraints of that proposed site plan.
Can you be more specific?
Yeah, there's a proposed user that would locate on parcel 2, and as they put together their site plan with their building and their parking, that's the shape of this and size that they need for their particular use.
So that's why it's,
Correct.
got it, okay. What are you gonna do with that Dominion Energy? You can't build over that, can you?
You cannot put a building on that. No,
Yeah.
just parking
Okay,
or landscape.
gotcha. So, but it is still developable as far as I understand it.
Yes, yeah, you just can't put any buildings, footings, foundations in that easement area.
I just wanna make sure that you're not leaving something behind that isn't gonna work.
I appreciate that, thank you.
I mean, you you thought that before I did. I'm just trying to understand.
No, yeah, no, I appreciate it.
All right. Any other questions for the applicant?
I don't have any.
All right, thank you very much. Thank you. Mr. Wright, so we'll open it up for a public hearing. This is where members from the public can come and give comment about this administrative decision. I'll remind you that for administrative decisions, the question it is not whether or not this is a good idea. The question is, does this meet the code? And so any input that you provide would be helpful in us deducing whether or not this is ready and meets code. So if anybody would like to share that, come to the podium. Seeing no response, I will close down the public hearing. The applicant response doesn't need to respond to the public comment because there wasn't any. Any further questions for staff or for the applicant from the commission?
I really don't have any on this.
Neither.
Okay. So I will open the floor for debate. My concern, as many of you have probably already detected, is that when there is a cloud on title and you start developing, it comes with some certain concerns. And as far as I understand things, moving down the road, once we go into preliminary, that clouded, at least specter of a prescriptive easement or a threat thereof, let's call it, could become an issue for land use approvals. That's the way I see it. But in terms of whether or not this conceptually works, I would agree with Mr. Wright that it's irrelevant at this stage. But I am very cautious and wary of things like that. We've seen it happen in the city before, and it causes problems.
There's some sort of, isn't there a law, Lisa, that when you use something for so long, property,
Yeah,
that it
7
becomes
years.
yours?
Yeah, that's what they're arguing, is a prescriptive easement, open and notorious for 20 or more years.
Sorry, say that again. So if they've been using it for 20 or more years,
Right, there's a number of factors, and that's why our position has been that in the past, yes, it's a private matter because there's many factual issues for a court to determine if it's been open and notorious and whether it was permissive. If it's permissive, then you likely do not have a successful claim for a prescriptive easement, but you also have to show that for a period, continuous period for 20 years. So there's a lot of testimony and evidence that would need to be submitted to a court to determine whether it's been open, notorious for a period of 20 years.
Right. And we're not making that decision.
Right.
My greatest concern is this: if they're gonna grant us a PUE on that northern portion that then also coincides with a prescriptive easement, then we may or may not have all of the landowners here for this application. Does that make sense? That's the way I reason, is if there are multiple land interests on that northern border and we're being granted a PUE, we're getting a clouded PUE. But again, I don't see that as relevant necessarily for whether or not this could conceptually meet the ordinance. It does, at least as far as we've been shown.
And by the time it comes back, who's to say that the parties haven't resolved that issue, right?
Fingers crossed.
Yeah, hopefully that's what they would do, right, is resolve it before the next step.
And even if it isn't resolved, it comes back during the subsequent stages, is that gonna throw a wrinkle in, I mean, it's just a little sliver up top, the northern part. Can you not still move forward with, you
Yeah,
know, the
would their
plan or
plan
the
not
concept?
Like, do they have to have
Because that's a
that?
private matter.
Yeah, we'll likely address that at preliminary. We have amended our code for what it says now, but they do have to show all easements of record as shown on a title
That makes
report. So our next legal question is a notice
Record.
of a prescriptive easement an easement of record?
Which it's not, right? Unless.
It's arguable.
It's not. it
We
wouldn't
just
show up in
found
a
out
title
about this
report.
today, so yeah,
Yeah.
we will likely have
table
to do
that.
some additional research with preliminary to see if this would hold up or
Yeah.
the development.
Okay, I will entertain a motion.
I'll make a motion. I hereby make a motion for the planning commission to approve the proposed commercial subdivision concept plan for the Legacy Commons conceptual subdivision plat located at the northwest corner of Parish Lane and 1250 West, affecting parcel numbers 06, 006, 0118, and 06, 006, 0082, with the following conditions, 1 through 3, and the suggested reasons for action A through D.
I second the motion.
We have a motion and a second. Any further discussion or questions on the motion? Okay, I will be voting against this, just so you know, because I think this ought to be tabled. That's my further discussion on the motion, in order to address the information we just received today. But we'll start down here.
Aye.
Aye.
Nay.
Aye. Aye.
Aye.
Excellent. That passes. Thank you, Mr. Wright. All right, item number 2, all right, getting up my bookmarks. Subdivision final plat, fourth amendment. This is an administrative decision. It does not require a public hearing, correct? However, item number 3 will, and they go hand in hand.
They're together.
And that's a legislative decision, so we're gonna have fun with this chimera. Mr. Eggert, are you gonna lead us? Okay. Ms. Deweese, please.
Thank you. All right. So just as a point of reference, you guys know how I do this. I give the highlights and hope that you guys have read the staff report. So the history.
Oh, I'm sorry, Ms. Deweese, I should have started with a disclosure. My apologies. So who's here for the applicant? For Symphony? Perfect. So I am a lawyer at a law firm called Fabian Vancott, and that's where Matt Anderson worked, and he represented the Packers in 2021. I was on the planning commission here at the time when this first came through, but I wasn't a lawyer at that firm. Through completely circuitous, unrelated events, I ended up at the same firm. It's my understanding that Matt Anderson no longer represents the Packers. That said, because there is that relationship and because I'm imputed to have all of the sort of same knowledge and representation of former clients, I wanted to disclose to you that that is the situation. I personally don't know anything about the Packer case other than what I was presented as a planning commissioner. Does that make sense? So I wanted to disclose that as a point of just making sure that we're all understanding the potential ramifications there. I feel like I can still make a fair and unbiased decision. Do you have any questions for me on that point? Okay, thank you. All right, sorry.
No, you're fine. You're fine. So this project is going to be a 2-application process. It went to the Board of Adjustments on January 13th, 2025. The Board of Adjustments approved the determination of existence and modification of one non-conforming parcel 07-072-0031 to connect to parcel A, contingent on the approved plat amendment parcel for the Summerhill Lane subdivision. Also to allow for the modification, boundary line adjustment in the non-forming parcel without affecting the determination of the non-conforming status, as well as to allow for the creation of a private access lane between lots 125 and 126 within the Summerhill Lane subdivision to resolve areas of dispute noted on the original Summerhill Lane subdivision plat and subsequent amendments. And then finally, to allow an additional modification boundary line adjustment between the non-conforming parcel and the Summerhill Lane subdivision without affecting the determination of the non-conforming status for parcel 07-072-0031. A copy of the board adjustment approval letter has been provided in your packet for this item. The board listed clear conditions for the applicant to adhere to. By way of applying for this subdivision plat amendment, this rezone, and the PDO amendment, the applicant is attempting to fulfill the Board of Adjustment's request. So, to get started, the application that we are going to start with, which is number 1, is the subdivision plat amendment. The applicant, Summerhill Lane, is requesting to amend the original subdivision boundary to facilitate 8 property exchanges from the Summerhill Lane subdivision to an adjacent parcel to the north, which ends in 0031, that is owned by Spencer and Pamela Packer. The affected Summerhill Lane parcels are currently zoned residential low, while the receiving parcel is designated agriculture low. As part of this request, the land is being transferred from the Summerhill Lane subdivision, as shown as parcel A in your packet on the proposed plat. This land will immediately be transferred to the existing parcel ending in 0031, owned by Spencer and Pamela Packer. Parcel A is requested to be removed from the plan development overlay, and this application has an understanding that it will be reviewed by the city departments, which it has been, and it complies to the city code. So just going over this as a brief, Centerville Municipal Code 15.09.090 states that City Council may approve the amendment of the plats or portion of plats along with the proposed easement, vacations, and relocation of the easements as long as on the following grounds. Number 1, there is good cause for vacation or amendment, and number 2, neither the public interest nor any person will be maternally injured by the vacation. So the staff response is the applicant has provided an extensive explanation of provisions that would be followed if the proposed subdivision plat amendment is approved. And based on this information provided in the application as well as the staff report, staff believe that the proposed subdivision plat amendment meets the reasonings of good cause, as number 1 states, and represents neither the public interest nor any person will be maternally injured by the project as stated in 2. The subdivision plat amendment request complies with all city standards and zoning codes. So that is my summary of my staff report.
Excellent. Any questions for staff?
Not at this time.
Okay, who's here for, oh yes, sir. Why don't you come on forward, state your name and address, and go from there.
Thank you for your time tonight. My name is Russ Wilson. I'm with Symphony Homes. Our address is 111 South Frontage Road here in Centerville. We appreciate all the help from staff. This is, as Sydney mentioned, this is step 2 of a 3-step process, as I understand it. We received approval from the Board of Adjustment for the Packers property to be considered one legal non-conforming lot. And so this application is to adjust our plat to accommodate for access to the Packer property and to adjust some of our lots within our plat. So are there any questions that you have that I can answer?
Not yet.
Is this application just born out from a private settlement agreement that
It is.
parties entered into?
Yes.
Okay.
Yep. So this is helping us fulfill that agreement.
Okay, no questions?
Thank you.
Thank you. Moving forward to any further questions for staff or the applicant? I guess no. And we do not need a public hearing, correct? All right, so we'll move, and I'll accept a motion.
I hereby make a motion to recommend city council approval of the subdivision plat amendment of lots 121 through 128 of Summerhill Lane, Fourth Amendment, which the following conditions 1 through 9. No, 1 through 12.
I second that. Oh, finish.
All with the following findings, A through D.
Okay, I've got a motion
I second.
and a second. Any further questions or comments? Okay, I'll start down here.
Aye.
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 All right, that's unanimous. Moving forward to item number 3, the public hearing on the zoning map amendments, a legislative decision. So, Ms. Deweese?
Yes. All right, so this is the third application of this. In this third application, the applicant, Summerhill Lane, is requesting the zoning map amendment and a plan development overlay amendment for parcel A, as shown in the plat. This is currently zoned residential low with the plan development overlay plan zoning, while the receiving parcel ending in 0031 is designated agriculture low. As part of this request, the land being transferred is proposed to move from the Summerhill Lane subdivision to the Packer property through the proposed subdivision amendment shown as parcel A on the proposed plat amendment. This land would be transferred to an existing parcel ending in 0031 owned by Spence and Pamela Packer once the subdivision plat is recorded. Parcel A would also need to be removed from the planned development overlay zone boundaries for the Summerhill Lane and then rezoned per the petition before it can be formally recorded and dedicated to legally connect to parcel ending in 0031. So the code requirements for specifically the rezone are that they need to answer the following questions. Is the proposed amendment consistent with the goals, objectives, and strategies and policies for the general plan? My comments were yes. The goals that they meet is extensive areas of semi-rural residentials for current property owners. I said parcel A being an access point to the road, Summerhill Lane for parcel ending in 0031 with no plans to develop parcel A is in the immediate future is kind of irrelevant for the density matters that is being discussed during here. Goal number 2 is to preserve the viability of the area for the potential future development. I said that in order to have potential for the future development, street access will need to be established, which is what the parcel A will be doing. Number 2, is the proposed zoning amendment harmonious with the overall character and existing development of the vicinity of the subject property? Staff comment was yes. What is the extent to which the proposed amendment may adversely affect the adjacent property? Staff says little to none at all. Number 4, what is the adequacy of facilities and services intended to service the subject property? The rezone itself would not require any additional services. So that was just strictly my review for the rezone. Now we are hopping over and continuing to do the analysis of the plan development overlay amendment. The PDO amendment can only be approved by the Planning Commission if items 1 through 3 of CZC 12.41.080 are true and meet the requirements. In the staff report, it lists what they are. The applicant has submitted all materials required for compliance of the city code, as stated. After careful review of that analysis, as represented in the staff report, staff is in support of the proposed rezoning to residential low to agriculture low and is in support of the PDO zoning amendment proposal for this process. The rezone request for parcel A area follows the requirements needed in order to grant the proposed rezoning and PDO amendment approval. So that is the end of my staff report summary.
Perfect.
Yeah.
Any questions for staff? Okay. And then, sir, for Symphony?
I don't have
Anything to
anything
add?
further to add, but happy to answer any questions if you have them.
This is a legislative decision, so I'm going to ask a few more questions that I didn't ask during the administrative decision. So this settles all of the conflict between the Packers and Symphony?
Yes.
You remember when we were doing this in 2021, you guys ended up putting a note on the plat about the disputed easements. Those notes are still going to appear on the plat, or are those going to be removed?
So the amended plat that we submitted has a note referencing those and an additional note saying that they will, I can't remember how it's worded, but
They'll be addressed with a recorded settlement agreement.
It's on the left and they're really small.
Okay,
Really small.
all right, just wanted to make sure I had understood that. That's it.
okay, thank you.
All right, this is a public hearing, so I'll open up the floor for public comment, if anybody would like to provide public comment about this potential rezone. Name and address, please.
I'm Spencer Packer. I'm the neighbor to the north that's been in this dispute with Symphony, and this is an avenue by which we can settle the matter and move forward. So I'm in hopes that you'll approve it. Thank you.
Thank you, sir. Anybody else? Seeing no responses, I'll close the public hearing. And sir, would Symphony like to respond to the public comment? All right, further questions for the staff or for the applicant from the commissioners?
No, I appreciate the fact that they were able to work together
Yeah.
and find a solution that works. It may not be perfect, but it works according to our zones, right?
Yes.
And according to them as neighbors.
Yeah.
All right, I will accept a motion.
I make a motion to approve. Oh,
Gotta do the whole thing.
Got to do the whole thing.
but I gotta have it in front of me.
Fair enough.
Go.
Fair enough.
I hereby make a motion for the Planning Commission to recommend City Council approval of the zoning map amendment for the property indicated on the plat as parcel A from residential low to agricultural low zoning and the plan development overlay zoning amendment for parcel A based on the following findings, 1 through 5, basically 1 through 4. Because we
I'll
have-
second that, yep.
Okay, I have a motion and a second. Any further questions? We'll start down here, Mr. Hoth.
Aye.
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 And I.
Very good, unanimous. Thank you, gentlemen, long time coming. All right, number 4 on the agenda is a zoning code amendment discussion. This is simply a discussion, we will not be making decisions today, is that correct?
Sorry, say that again. I
That's okay.
apologize.
No, just moving on to number 4. This is the zoning code amendment discussion for body art facilities. We're not making decisions today, correct?
That's correct.
So in the future, we'll be having a public hearing. Today is not that day. All right. So for those of you that are in attendance, we don't have any more public comment periods, but we'd love to have you stay as long as you wish, if that makes sense. All right. So who is leading out on this one? Mr. Eggett.
It'll start with me probably, and then Lisa will be able to interject how she sees appropriate, because I think she'll have some things she might want to add. So I'll do the best I can, Lisa, and then let me know if I miss something you want to chime in about. This has got a lot of history on it. I'm sure most, if not all, well, absent our new planning commissioner, Mr. Woodward, are aware of the history on this. This discussion started back in October with an applicant, Nicole Hutchins, regarding a request she had proposed for body art and fine line tattoos at that time. Through meetings with the city council on November 6th and February 18th, there were public hearings that were held before the city council by the city for the request of the applicant on that. The public hearings were very, very involved, and at the conclusion of the most recent meeting on February 18th, the city council discussed and debated the request by the applicant. Ultimately, at the end of that discussion, came to a conclusion to deny the application due to concerns with the location of the applicant's business on Main Street, hard to differentiate definitions of fine line tattoos versus any other tattoos, and other administrative and legal logistical concerns associated with the applicant's request. During the discussion following the council's decision, city staff was directed to evaluate the city's risk relative to the matter and the current status that no tattoo establishments, body art facilities are currently allowed in any zones within the city. And further, staff was directed to work on new language regarding this concern, identify potential locations of this type of use within the table of uses for commercial uses, and then bring proposed new language forward to the planning commission to start a new discussion on this. There is a concern that there should be a zone identified in the city zoning codes for a tattoo establishment / body art facility. I think going forward, I'm just going to call it a body art facility, if that's okay with the planning commission, somewhere within the city. Additionally, the city council noted throughout the deliberation that there wasn't necessarily a concern with the idea of establishing a zoning area to allow for a body art facility somewhere that makes the most sense within the city, but the applicant's requested location would not be best suited for consideration of this proposed use. So they were aware that there could be some identified concerns with the zoning ordinances, but that this request and the location for the request was not good for the city. That's the best way I could reword that. To that extent, there have been 5 elements that are being proposed through guidance of proposed ordinance number 2025-04 that our city attorney has worked on. The summary matches that ordinance. So if you look at items 1 through 5, you'll see that outlined therein what those additions or changes are. A public hearing, like you stated, Chairman, will need to be advertised for the proposed zoning code text amendment should we move forward with that at a later date, and it will need to follow state and city code requirements as such. Now, looking at the staff analysis, it may be a little premature to do it, but it felt like the right thing to do in light of the weight of the discussion. And so you can see that the only real guidance for the general plan, much like the previous reviews of some similar requests, are tied to Part 12-430 development. And you can see that what those terms are. I took it over and just imported it into this report for your own review. There's not really any direct application as it relates specifically to the context of this discussion, but that's the closest thing that we would have in the general plan. Moving on, then we look at the nature of the existing codes found within CZC 12.12.040, 12.36.040, and then the other associated codes relative to conditional use permits, resident or home-based occupations, et cetera, and some of the amendments that were identified. The term body art facilities is a more aligned. It's more aligned with what the state code and the Davis County Health Department uses as nomenclature for these type of activities. So that's obviously low-hanging fruit as to why that recommendation of change is being found within the documentation. Further, body art facilities, where we go with that terminology, would need to be represented as such in the table uses for commercial uses. For the other associated proposed code amendments are not reflected within the current version of the city zoning code and lead to, either spot minor amendments or things that need to be adjusted so that the current functioning of the tattoo establishment language continues to operate as the way that it was intended to, as it relates to permanent cosmetics that are already established and allowed by code. So it's trying to further tighten, I guess you'd say, the screws or clarify some of the language as it currently exists within the code as part of this process. As you can see under the grayed out area in that bottom paragraph, this all being said, there could be a potential constitutional concern in respect to the distinction of establishing an identified zoning code location within the city's zoning code. For this purpose, this matter is being brought to the attention of the Planning Commission for further deliberation, discussion, and direction to the city staff. City legal and city staff are the opinion that these concerns should be discussed and evaluated to make sure we are making a potential zoning code decisions that are in the best legal interest of the city. City staff plans to provide a more formal recommendation regarding this matter at a later date when the zoning code text amendment proposal may come to the Planning Commission for formal consideration in the future. So what we're looking for ultimately, if you look under possible motions, is some kind of consensus direction or guidance on how you'd like to move forward with this discussion as far as dates, public hearing, if you want to deliberate further. I do know that Lisa may want to add some additional guidance and commentary, so I think I'll defer to you, Lisa, to add anything you might want to add before we turn it over to the Planning Commission and go from there.
Yes, thank you. I think this proposed amendment is to address some concerns of the City Council. As we discussed this with the prior application, there are some concerns with free speech rights and whether we can completely ban body art facilities within the city. My position is that it's unclear in Utah. There are a number of cities that prohibit tattoo establishments or body art facilities. However, it has been deemed unconstitutional in the 9th and 11th circuits. Utah, the appellate court is the 10th circuit. So that's why I'm saying we don't have a 10th circuit court case, at least that I found, yet ruling in Utah. But we're looking at these other jurisdictions, which sort of indicate the direction that appellate courts are going. And so I have mentioned that it is a risk to completely prohibit or ban these types of facilities in the city. So the recommendation was, I think as Mr. Eggett has mentioned, that, Main Street might not be the appropriate place, our commercial medium zone backed up against residential, but we should find some place in the city where it's appropriate. So this ordinance is bringing that back, trying to close that gap, and we wanted to bring this to the Planning Commission to just have you review this and make sure that we get this ordinance on the books so that we can initiate the pending ordinance doctrine as of this time.
And you'll see a recommendation in 12.36.040, the attachment of the locations that have been recommended as conditional use permit.
Down right there.
Can we see that,
Can we
please?
go to 12.36?
The third attachment, Sydney,
Right there.
click on that. It's pretty small, but yeah, you can see in body art facility there, under CVH, specifically in the CVH PDO of Legacy Apartments and Legacy Crossing, otherwise no in the CVH, and then in the IH and the LVH. Those are our staff identified potential.
Yeah, so there's a couple pads left in the Legacy Apartments. There's two right near the roundabout that potentially, that's in the Legacy Crossing PDO, or Legacy Apartments PDO, and then we also have the Legacy Crossing, which is just the other side of 1250 west of that. And then any of our industrial high or industrial very high. I see it's recommended no in industrial medium, but I'm not certain we have any industrial medium zoning in the city, so that may be why it's no.
Yeah, well, and yeah, per the guidance, but clearly that this is, again, one of those areas that the discussion of the planning commission and guidance to make sure that we're going in the right direction as far as in the future, when we make a recommendation to city council, this is kind of where we want to play. So, yeah, but if in an industrial medium were to need to be changed to conditional, everything is, I think, in play at that point.
Where would we have an industrial medium?
Certainly, there doesn't exist one. I mean, I guess we'd look at the
use table.
table of uses and identify kind of the types of uses that would be in it. But the industrial table of uses is not very dramatic. It's pretty simplistic.
We wouldn't do that up in the SCP, would we?
You have three, you have a conditional use and you have two permitted uses in the industrial medium zoning. So general manufacturing is conditional in the IM zone. Limited manufacturing is permitted in the IM zone, and limited wholesale and warehousing is permitted in the IM zone. That's all that would be in the IM zone, generally speaking.
So, to be clear, because that was a lot of stuff, pretty fast for me. So basically, nothing east of the freeway.
That's correct.
Yeah. Yes.
And I don't know if this is an appropriate question for you or not, because we're not talking to anybody else, but you can just tell me if it's yes or no, if it's appropriate or not. So I know that what they're wanting, and I know where they're wanting it, right at their location on Main Street. Has it ever, if this is what they're really pushing for, and this is what they really want, and if they get this approval on the other side, has it ever been mentioned that they would actually move their business?
So during the public hearing on the 18th, that came up, I believe it might have come up on the 6th as well, and the applicant said that they have no intention to relocate, that they would like to continue to do business where they're at. That's what the applicant indicated, that it doesn't benefit the applicant in any way. And again, this is the reason that we're trying to separate the two, right? That we want this to be a city
Right, this isn't just for one business.
Yeah.
Right,
Yeah.
so, yes, this is a
To
city
clearly
initiated.
separate it so that
Right.
whatever she's interested in is not part of this. But to your question again, the representation from the applicant during those hearings was that they have no interest to relocate from where they're at.
And are they threatening suit or something like that, or?
I
mean, is
haven't
it-
heard anything specifically, have you, Lisa?
I think the city council is just trying to be responsible and, you know, closing this gap in our ordinances and reducing the legal risk, so.
Yeah.
Okay.
And I believe the vote at the council was 3-2.
It was, and that's
So it was a split vote,
reflected in
but the direction was to work on finding, you know, working on the definitions, because the previous application, we were trying to parcel out fine line tattooing, so we've eliminated that distinction, and now it's just body art facility and permanent cosmetics. And both those terms are used in state law as well as county regulations. So that's why we're, as mentioned, we're going in that direction.
And that was the copy and paste that you mentioned. Basically, you took that from city or state and county?
Well, the state defines body art facility broader than we are. As we're saying, we're not, I think the county prohibits scarification,
Yeah.
some of those things that are listed at the state level as body art facilities, but Davis County does prohibit a number of things, which is what we've done, and, trying to find that.
It's in,
I think
it's
it was
in,
above it.
yeah.
In the
there you
red
go.
line.
Yep.
Yeah, so in ours, we just allow body piercing and
So then
tattooing
you go to the top.
under our definition of body art facility, but I know under state law, there's a few other things. And then, body art facility in Centerville, as well as in Davis County, I believe, does not allow branding, scarification, or any practices that are considered medical procedures, which obviously are different use.
Yeah, those three terms are CDE on the state definition of body art facility.
While we're on that, I had a question that I was gonna raise, but just do it right while we're here. So in the county regulations, they also include the biopsy punch as forbidden. Would you have considered that subsumed into our definition of medical practices, medical procedures?
I think.
'Cause I don't know, like-
Because I don't know if the biopsy punch was under state, so I just.
It was under the Davis County's regs.
But they do that at the dermatology.
I know.
I've gotten them.
That's
I've
what
had skin cancer.
That's why I'm wondering, like,
To me, that is more of a medical procedure.
Yeah.
that's what I would have thought too, but for whatever reason, the county calls it out.
But I don't think the state,
No,
but I can look back at that. I don't.
just something to think of. If the county's calling it out, somebody decided it was necessary, and I'm wondering why. That's my ultimate question. If our definition captures it, great. If it doesn't, great. Right? Either way, I just want to understand. We're moving on to questions, is that all right?
Unless Lisa's
Yeah.
thinking more, I think so, though. I think we defer to the planning commission.
So like the tattoo establishment, that section is just completely taken out? It's because it's redefined elsewhere, or
As
Yeah,
well.
we're just trying to use the more
the broader?
broader term of body art facility.
Okay.
The county also talks about suspension piercing. Do we We
No,
don't-
we didn't get into that.
What's that?
call it?
I don't know.
What is, I don't know.
Pretty extreme.
Is it?
Yeah.
Explain.
Well,
Would.
the briefest of it is that it's a practice
If it's-
where you put hooks in your skin and you suspend yourself.
Oh, my
Oh,
God.
geez, okay. So presently, there's no tattoo artist in Centerville with a shop that's open for business.
Yeah, it is currently not permitted in any zone as it currently sits.
Even cosmetic, like permanent makeup kind of things?
Cosmetic is allowed in a salon setting.
Oh, okay.
So that was going to be my next question, if that's okay. Is that in our definition compared to, say, the counties, we add language that says,
Go
and
back to that, Sydney, please.
I'm right there at that, nope, right there.
Right,
Nope.
just in the middle, personal care service.
Oh, personal care, thank you.
Okay.
Or do you want to go up to permanent cosmetic?
Actually, go to permanent cosmetics.
Okay.
Right there.
fourth line of permanent cosmetics where it says, the eyebrows, eyelids, lips, or other parts of the body for beauty marks. I just, and again, this is just me playing armchair quarterback, so take it all for what it's worth, guys. Big dose of salt. When I look at other parts of the body for beauty marks, and, I mean, yeah, we could, there's a lot of range for what that means, in my mind. I think that somebody that's enterprising could try to argue that beauty marks could mean more than what we would traditionally consider eyes, lips, and eyebrows. And when I looked at the county's regulations, they were tighter on that. And so it's just a thought. That line may give grief in the future. Next one down. Personal care has as its definition, so down a little bit farther. Fourth line in personal care talks about electrolysis studios. And the reason this was curious to me was, we're gonna do as permitted uses home occupations that allow electrolysis. Is that what we do already?
It's already, that's current code.
Okay,
Yeah.
so isn't electrolysis, I mean, that's a little more extreme than just, say, hair cutting.
It's hair removal.
I know, but it can be a little bit more extreme. I'm just wondering, why is electrolysis there? And this is expanding things a little bit farther, but the rationale behind why we are exempting out from personal care these other things is that for home occupations, it's low risk enough that you don't need that kind of regulation. This is a bit of a rabbit hole for me, non sequitur perhaps, but why is electrolysis there? Because
I'm not familiar enough with electrolysis
Me either.
to answer that.
me either.
So we were just
I'll
looking at
second
the
that.
Yeah.
tattoo, so. But what, permanent cosmetics is still under the definition of personal care service.
Right.
But we exclude it because the conversation did come up at the council, well, wait a minute, can you allow this as a, home occupation? And so then we said, okay, you can have personal care as a home occupation, but not permanent cosmetics.
Right.
So
Right.
if you, want us to look into
No, I
the
don't.
risks of concerns with electrolysis.
This is the canyon I want us to avoid getting boxed into. If electrolysis is as risky as permanent cosmetics, why are we allowing it as a home occupation? And if it isn't, great. I just don't know.
Right, and that would be easy enough to also just say excluding permanent cosmetics and electrolysis.
If indeed, right?
Yeah,
I just don't know.
but,
What would be, so we as staff knew, if you wanted to look into it, what would be the basis of risk that you're wanting us to understand? Like, when does it cross a line that we would recommend removing it as a comparative risk?
I don't know. Is it regulated in the same way as tattooing, as body art
Okay,
facilities?
I mean, that's what I mean, I could do the research, right? But I want to know where that
Right.
distinction is of
And
risk.
it could be that it is distinguishable simply on its face. Electrolysis may not have the same type of tight regulations as tattooing because it doesn't pierce the skin, it just simply fries the hair.
So what I hear you saying is maybe see what state and local regulations are as far as the county.
Just briefly enough for us to feel like
Okay.
electrolysis
We've at
is
least looked
still
into
fine
it.
for a home occupation.
But if you're gonna look into that, you also, because it is separate, it may be in the same family, but it is separate, laser hair removal is not electrolysis. That is something different,
Okay.
both of which you can actually be burned from.
Where's the laser hair removal?
It's not.
Oh, it's not there.
That's what I'm
It's not
saying.
included.
So,
So you're suggesting possibly including that
well,
term?
yeah, I'm saying if we're doing electrolysis, why aren't we doing laser hair removal?
Well,
Because they are different.
my biggest concern is that if it's a home occupation, that's different than a business front, right?
Right.
And so when we allow home occupations as a permitted use, including personal care, and then exempt out body art facilities, or how's the language go? Excluding permanent cosmetics.
This is typical uses include permanent cosmetics.
But if you go down to, Cindy, go down to.
Permitted
Keep
uses.
going, right there, B.
Yeah,
That's what I think Chairman Kerr's referencing.
so,
So personal care.
again, I may be fixing a problem that doesn't have a need for a fix. It was just simply something that came to mind.
Well, and there's two ways of thought to look at this. That's why I asked the question,
Right.
like, we have all this code, we can fine tune the screws as much as we need to.
Right.
Or we might be going down too deep of a rabbit hole on some of
Right.
these things that it's.
We want it to be broad, but maybe
Do we
not
know
too
if,
specific.
do we know if people are doing the electrolysis studios in home right now?
I would bet you it
You're
isn't
in
happening,
Centerville?
but I would have to do an audit of our business licensing to tell you. And even then, with the state regulation on home occupations, not everybody is required to submit these days unless there's a health, safety, welfare concern. So even then, I wouldn't necessarily know even if I asked
Full
the
universe.
business license officially.
Okay. So playing devil's advocate, as we lawyers do, this may be too much, a far afield, and we can just solve the problem we have in front of us.
That is what I am worried about in my
Okay.
comment, yeah.
That's fine. And then, let's see, what were my others? Oh, in the table of uses, what are the conditions upon which a typical body art facility would need to show to qualify for a CUP, right? Like, what are the detrimental impacts that you guys can think of that we're gonna have to mitigate? Other than the typical times of use? Because it certainly isn't gonna be, we don't want the riffraff.
Yeah, no, I thought you talked about like times of use, maybe storage of chemicals or anything like that would be in a neighboring business they wouldn't want. I don't know, again, I don't know
Yeah.
what solvents or other things they would use, but something like that was what I was thinking. So at least, making sure they meet fire regs and requirements would be one of them, I would think of a big one. And like I said, hours, making sure they're following standards on hours. I mean, we could certainly look at what even other cities have as conditions so that we have a better understanding
It'd be
of
nice to
that.
know, and
Yeah.
I don't necessarily want to spell it out, but here's the thing. As soon as you get a CUP application for a tattoo shop, we all know what's gonna happen.
Yep.
We all know what's gonna happen. People are gonna come in here and they're gonna say, you cannot allow this.
Yeah.
And that's the completely wrong question. So my question is, why not just make it permitted and call it done?
And that was the reasoning, at least we talked about CUP.
Yeah.
Was if they have any chemical solvents and hours.
Yeah.
But I could look into it and bring
Because
it
they're,
back.
look, this is just my position. They're so tightly regulated by the state. What conditions are we as a city seriously going to
Even-
impose on them?
Yeah, and even regulatory with like making sure Davis County is
Yeah.
involved, but we have a requirement in here with that code. That's why you see in the table of uses, you have a C and then you have a question mark by it.
Right.
Because it's even questionable, should it be even conditional?
That's right.
And that's why it's evidence as such on the table.
Well, I always think of conditionals as, permitted uses upon which reasonable conditions can be
Right.
applied. And I'm not personally seeing any conditions that we as a city could regulate a tattoo shop that isn't already taken care of by a different body.
Yeah.
Which is why I just think, make it a P in the industrials and call it good.
What does that mean, make it a P?
Permitted.
Permitted, that there,
Okay.
no governmental review would be staff review, subject to the typical requirement of code.
Okay, so then devil's advocate on the other side, because you and I do well with this. The other side would be, going back to what you said at the very beginning of the meeting and what you read, right? We plan these things, but for the city and for growth and whatever, but we also love what we have, right? And have to respect what the people's wishes are. So sure, we could just do it and push it through and make, figuratively 80% of the population pretty upset over it. Or we could ask, or we could, I don't know. I have a hard time just saying, let's make it pass, just because.
Without getting input?
Without getting input, because we know the residents of Centerville, a lot of them would not want that.
But that's the slippery slope with having a public hearing for an administrative matter, because really we would have to show the detrimental impacts. And that's my same concern, is what detrimental impacts are you going to show?
More
It's going to
evidence.
be more public clamor, which is not appropriate to take into consideration in an administrative
Correct.
decision.
Right.
And
You're right, though, for the legislative. I'm not saying that let's call this good. What I'm saying is that if our code is written in a way, our code should be written in a way that is made very clear to both applicants and the public what is an appropriate decision-making foundation,
Agreed.
right?
Agreed.
And conditional uses are so commonly misunderstood by the public that they come in thinking that they're going to be able to affect change when that's not what happens.
No, that's why I was thinking, like, I could do a survey of other cities and see if they have conditions spelled out.
Right.
Because maybe those conditions could be replicated and inserted in the code so they're clear what the condition expectations are if we go that route.
That might work.
And
then
that
you
was
at least have a
the,
basis.
yeah, that was the intent with if you can show the new, however you call it, yeah, right there, the 1255. This was the intent of this provision, is saying, hey, we allow these things in certain places of the city, but no, you are regulated by state law and county
That's
health
the
regs.
conditions right there.
And so whatever they require, you need to comply with. And that's sort of the question is, hey, is there already enough at the state and county level? What conditions would Centerville put on there? In terms of public health and safety?
On top of this.
Yeah. But, you know, I suppose if there was something that applies everywhere, but again, in our industrial zones, you know, that was just sort of the reminder that these are regulated and if approved, they have to be.
What is the applicant's current business at the current location on, is it Main Street, you said?
The previous applicant's business is approved for permanent cosmetics.
Correct.
The city is the applicant for this zone change.
Yeah, and again, this is why we brought forward even the table of uses, like, is it conditional, is it permitted? What seems to feel right from the planning commission, because then we as staff have to represent your wishes at whatever point we're to proceed forward to the council. And the council still may have the same questions, well, this should have been conditional, and here's why, right?
Yeah.
So we want to make sure we're really vetting this out to get it right and bring it to you first.
Well, those are all the seeds I gave for thought.
Okay.
What else?
Was there an
Anybody-
indication from the city council that they wanted this in the code to be amended this way? Or was it more, hey, let Farmington deal with this, or, I mean, let Davis County, you know,
My
if
understanding-
you want to go get a tattoo, you can go wherever else in the state or county.
It was
No, I think-
Maybe not make it a Centerville issue.
I think the council was, certain council members were indicating the legal risk of a complete ban in the city, and so they directed
Was that
staff.
the three versus?
No,
the
There were
it was
actually-
just comment.
Actually,
Oh, okay.
yeah, more broadly speaking, I think there was more broad support for us doing the very thing we're doing with the U.S. Planning Commission right now.
Right, and so I think it was the majority, though,
I
that
feel
did
like that,
direct
too.
staff to come up with an
Yeah.
ordinance, you know, broader, a broader definition of just body art facility and recommended zones for where that might be appropriate.
I feel like they recognized the concern that staff brought forward, but they were worried about the cloudiness with the applicant's request at the same time. And it seemed to be confusing the issue, so this gave them opportunity to bifurcate them completely separate. So this could be city-sponsored in trying to resolve some, or not resolve, but come to a more current solution to the situation.
And then if we are making it in the code and specifically, we know where that applicant resides and now we're moving the zoning outside of where they reside, is that, you know, gerrymandering in a way or some other constitutional issue that they
No,
could?
They can, once we adopt a code, anyone can apply for a business in the location that's appropriate. And it solves our free speech issue because you can regulate time, place, and manner. And so we're bringing back a time, place, and manner that's appropriate for Centerville.
Okay.
So for me, just to be clear, kind of going back to what you said, you were saying, you were wondering if city council was saying, hey, let Farmington and Salt Lake, whatever, deal with it and not Centerville, and, or were they talking about a complete ban? And then you guys had mentioned, I think maybe Lisa, one of you had mentioned something about a ban. It's not that we ban it, right? It's just that we don't have it in the code, right?
There's no
Well,
zone.
we do
that-
not allow it.
Presently.
We currently do not allow it,
Yeah.
period.
Yeah.
Okay,
That's
okay.
correct.
So yeah, we do ban it.
In essence.
As per, but- okay, but as per.
It's not allowed.
What the citizens have wanted, right? Previously, somebody obviously wanted
Do we
it.
know, like, the history on,
No, I think a lot of it's
it probably wasn't a thing.
been in our code.
Hasn't been a thing.
Yeah.
Yeah. I did have a question, going back to, if you could go back to permanent jewelry, no, sorry, permanent, whatever it
Cosmetics?
is, we're all over the place right now. Permanent cosmetics. So this is what you would want to change it to? This is what you're suggesting in the red, right? Okay. So this says insertion involving the controlled insertion of pigment into blah, blah, blah. Would that include cutting? Or is insertion so broad, is it so broad that it encompasses anything that's an insertion? Or is that an insertion like just a needle?
Yeah, it was intended to
pigment.
just be the needle, that's how it's used.
Because microblading of the eyebrows is with like a little scalpel, and they cut, and then they take and they rub in the color.
Yeah.
So
So, yeah,
that's
it's not,
something
it doesn't
different.
define what they use.
Okay, so if it doesn't define, that could cover
Yeah.
that.
Well, and
Okay,
yeah, I think the state does talk about permanent cosmetics, including microblading.
Okay. Because it can be done different ways, and if we're gonna get into the nitty-gritty, is that included into that? Okay.
Yeah, if we felt like we had to add that definition, kind of like this, Lisa just said the state did, including microblading, clearly we could insert something to that effect, even in parentheses if necessary, to make that even more
But
clear.
if it refers to those, then they would just have, the state county, they would
That's
just
right.
have to go and look at those to
Then
make sure they're
additional phrases.
compliant.
That's the intent, is for
Yeah.
us to work in tandem with the state and the county, so it's almost a triad of regulations, so that we're all on the same page.
I
on how
like
we-
that.
Yeah.
Yeah,
right.
okay.
And then if for some reason the state or county changes, then ours would
Some
automatically.
flexibility to follow their deference.
Okay. Okay.
Yeah, I think this makes sense to, we want to respect if somebody really wants to do that. I mean, it's not that it's going to allow 50 new tattoo places.
That's not the intent.
I mean, business is not going to allow that either, right? I mean, it's going to be the cream of the crop rises, and you maybe have one or two here in Centerville.
Yeah, it's like any business.
Yeah.
There's only so much of a marketplace for any of these industries, yeah.
Yep.
So this business is adding additional services to their menu.
They want, yes.
But they couldn't at the location.
Got
Right.
Unless,
Unless they're out of the zone.
yeah, or no, out of the city currently. They can't do it at all in the city currently.
Yep. So then the zone would only be
Yeah.
west of the.
Over by the movie theater.
Yeah,
By
it'd
the
be only
roundabout.
west of I-15.
That's, I mean, that's a great commercial area. You can grab a Mountain Dew and go get a tattoo. I mean,
Sure.
I may skip out on the tattoo part, but I do like my Mountain Dew.
Yeah, that's clearly the intent.
Well, I like it being with some similarity down there. It seems more prevalent. I don't know. Like you said, having residential right in the backyard of a tattoo shop may,
That was some of the council's basis for having challenges with it, with the,
Yeah.
the request.
you know, and I had a friend, full disclosure, she reached out, and she's not within the city boundaries, but she said, well, just pass it, let it happen. And I'm like, with all due respect, would you want that in your backyard? I don't, just keep for thought.
So from a direction perspective, do you want us to do a little bit of homework and bring it back at the next meeting, or do you want to give us maybe up to a month to do really good thorough research
Yes.
and bring some stuff back?
Thorough.
Do you want us to look at like even maybe some neighboring city regulations just to get a survey?
Yes, please.
An audit of like
Well,
the neighboring
couple
cities, and a
surveys
few,
to
and maybe
see-
even one
Can,
completely separated from the county.
Don't overwork yourselves.
I was thinking like up to maybe 5 neighboring
Yeah,
communities
I
or
think-
something.
like within Davis County?
Yeah.
Yes,
Yeah, sure.
it's Davis County.
Yeah.
Now, the only caution there, just because other cities aren't doing what we're doing or haven't addressed it, doesn't necessarily mean it isn't something that needs to be addressed. Remember
Right.
what our
Right.
city attorney has represented, so.
I'd just be curious to see if there are tattoo shops, within,
One, how they define,
yeah,
good.
Body art establishment.
thank you. Thank you
Yeah.
for that
no tattoo
clarification.
shops anyway.
Okay. I think that gives me enough to work with. What about you, Lisa? Does that work for you?
I'll keep you busy for a while.
Thank you, appreciate it.
We don't need any more work to keep us busy. We'll put it that way.
One more thing.
He gets bi-weekly calls. Excuse me, what's
I think all
Carl's
three
Jr.
of us-
going to be?
I think all three of us wish we had a little more time in a day to get things done. Let's
I'm
put it that
sure.
way.
No, that's gonna be gone.
All right, so closing down that discussion, unless there's more.
I'm good.
You're taking that way.
All right, moving forward on the agenda, we are going to the Community Development Director's report.
Yeah, and so maybe just one quick thing to note with our item number 1 on your business item, I did reference in that report that there is a site plan pending. I have received that with this meeting tonight and the conceptual plan moving forward. I will start to process the concept site plan. So you will possibly see that at either the next planning commission meeting or more likely the one thereafter. So just a heads up there, get a better feel for what lot 2's identified request is at that point. We do have a few other subdivision processes that have started that you may see as well coming in the next month to 2. So just be aware of that. There are a few things that will come at least to the planning commission, even under our new standard. Like we have a 4-lot subdivision that's starting a conceptual process right now, and a couple of other subdivisions, so be aware of that. And then I'll slide into item 2 under community development director's report, because I think that's pertinent. This is tied to one of those developments that I'm referencing. So we have a product or a project that has a unit count that would work on a property, but the property is shaped very, I guess, less favorably, disfavorably, I don't know what the right term would be, for the applicant's request for that property. As a result, the best solution for the applicant's request is to look at doing a PUD. With the PUD, historically, the community development director and staff would run a PUD through a planning commission and city council review. But with the state code amendment that has now hit, developments don't proceed through that same process. So it puts the PUD in this weird posture because the PUD seems to want some review by the planning commission city council for some variation or change to a typical subdivision development, right? It's not just straightforward administrative. As a result, it creates challenges for us as staff, okay? Now that we don't have the opportunity to bring it to a planning commission to make a recommendation to city council and city council stamp it because the state code and the city codes have changed, there needs to be some kind of tool to look at. And with the state code, we have the opportunity to explore the use of development agreements when we look at how do we approach variation. So I'm not necessarily seeking even a lot of discussion. I don't even think I'm seeking discussion as much as to give you an introduction of why this is provided in your packet. What we try to do here is replicate what has been done recently with the plan development overlay language, so it will seem and feel very familiar from that perspective. That's by design, because again, you have this weird new gray area of, okay, how do we provide the variation but respect what our own code has provided? And the best way to do that is to provide an agreement so the applicant knows that they're entering into that relationship outside of what otherwise would be provided to them administratively. Now, to this applicant's request, it does benefit them because they can take a lot that would otherwise only provide maybe 4 units and they can potentially get 6 home units out of it, but there has to be some variation provided to them in order to qualify for that. And so that's why you see in your packet this planning and development standard. I don't even think it's necessarily like spot on perfect, but it's an attempt for us to integrate those similar PDO concepts into it so that it becomes another tool that can accommodate something like this residential development. And what I didn't clearly state, Sunny, is it 1 acre, 1.5 acres? How big?
It's 1 acre.
1 acre. So again, I don't know if you remember, but a plan development overlay is set up at 5 acres or larger. So again, we have a planning and development tool that now seems a little orphaned with the change to the subdivision ordinance. So we're trying to find a way to better plug it in. So this tool, if it were put together correctly with the right provisions, could better accommodate something that is under that 5 acre total and more geared towards a residential concept. So it gives us back tools to better use it and bring it back to a position where the planning commission, city council would again be able to review it for more of the perspective of the development agreement, which would be viewed as a legislative tool, because we have to treat them as such with a public hearing and treat them as a code amendment for the purposes of a project request. So that's why you have it presented like you did in the packet. So I just wanted to give that primer to you. So what I guess my homework request would be, because we do have an applicant that's kind of in a limbo state, for lack of a better word. We're continuing to work with them. City is working with them, and we're bringing them to DRC as it relates to the administrative stuff that we otherwise would review. But we need to get a better grasp on how PUD work. And again, I know Lisa probably hasn't even looked as closely at this as well, so we would want further review of it from that perspective. but we want to try to work through the language and bring it forward, hopefully at the next planning commission meeting, I guess, for lack of a better way to say it, to at least debate and discuss it, and then schedule it for a public hearing thereafter, so we can get this thing moving and try to help this applicant move forward in tandem with his review process with Sydney and the DRC. He's anxious. The good news is he just barely got back to us today on some updates on his designs, so we're still gonna go through a process, so that will allow for some time. Sound like you wanna say something, Sydney?
Yeah, I also just want to say that this was a application that showed a larger issue within our code. So even though that this applicant was the one who highlighted it, the reason why the city is going to be the applicant for it is because it really is a tool that needs to be established for any kind of development moving forward where variations are involved. So when I do a staff report for any kind of subdivision, or if I do a review for a building application, I need to understand the setbacks, the impervious surfaces, and everything that entails. And with that being said, with planned unit developments as they stand, they do not have to state any of that in there, which is extremely pivotal for me because I came across that in a application, and thankfully the applicant, separate application, but thankfully the applicant was willing to work with us and get that established. But moving forward, this was something that we want to take what the PDO has for 5+ acres and make it so then the PUD has it for anything less than 5 acres is basically what's happening.
And we could even make it more restrictive if, right now, in the green, you can see it says residential, commercial, industrial, mixed residential, commercial. We can even debate the merits of, do we want PDO to be something that's 5 acres that's geared more towards commercial and kind of tone this down to be more residential or mixed use residential only? I mean, there's some nuances here that we're open to exploring with staff. But again, we want it to be a tool to help those properties that could be developed for more units by zone allowance, but can't by geographical boundaries that are odd or unique that make it hard to develop what otherwise the zoning code permits. That's what we're trying to accomplish. I said more than enough, and I'm not really expecting feedback, but I guess the homework would be for you. Look at it, come with ideas for the next planning commission meeting, and let's have a good hearty discussion to try to bring it forward as
Is there a subject property on this particular one, or not yet? Okay.
we have an application, I guess, well, yeah, probably, that's
Okay.
probably premature at this point.
Okay.
Let's leave it at that. So, anyway, that would be my report.
Very good, thank you very much. Moving on to the minutes of prior meetings, let's review those. So our minutes from February 26, 2025. Anybody have any proposed amendments or changes?
I read through them.
Short.
Yep.
Okay, I'll take a motion.
I make a motion to approve the minutes.
I second. We have a motion and a second. All in favor, say aye.
Aye.
Aye. That's unanimous. I'll take a motion to close.
Motion?
No, wait. I have a question
Okay.
Oh, my apologies.
for these guys over here. So I keep seeing signs about high density and vote no city council and some vote yes city council. Can you expand on that a little bit?
Well, before we do that, in an open public meeting, why don't we just talk to them afterwards?
Okay,
Because we aren't noticed up for a discussion about that.
That's true.
okay,
It's a good question.
thank you.
Yeah.
I just want to know more about that.
That's true.
Okay.
Okay, so,
I make a motion to close.
And I second it then.
okay, then we have a
Okay.
first and a second.
Okay, so we're closed. Okay, so
All in,
now,
hold on, all in favor, say aye.
let me do it,
Aye.
man. Aye.
That's unanimous.
And you have the floor.
First motion to adjourn, it was almost voted no.